Hi, everybody, and welcome to the third webinar in this series on responsible prosecution. My name is Jennifer Doliak. I'm an economics professor at Texas A&M and a senior fellow at the Niskanen Center, which is hosting these conversations. The goal of this series is to bring evidence to the often heated policy conversation on the role of prosecutors in the criminal justice system and the effects of various policy reforms targeting prosecutors' behavior. Our focus here is on research evidence that measures the causal effects of prosecutors and related policy reforms, that is, research that distinguishes correlation from causation. We have another fantastic lineup of top scholars who are going to share their work with you in short presentations, 10 minutes each, with an emphasis on policy implications. We're going to go in the order that they're listed online, and let's just dive right in. So Megan Stevenson is up first.
Thank you so much. Let me get my slides up. All right. There we go. So nice to see everyone, or to see my panelists and to know that you are out there. I'm so glad to hear that prosecutors are interested in learning what us nerdy academics are thinking about. And I'm really looking forward to sharing some of my research with you. So this is a paper about the impact of pretrial detention on case outcomes. So let's start off with this quote. So in an influential Supreme Court decision, Chief Justice Rehnquist wrote that in our society, liberty is the norm and detention prior to trial or without trial is the carefully limited exception. So this is aspirational, but this might not be the best representation of our system as it currently exists. So of the 1.9 million people currently incarcerated in the United States, 445,000 by most recent count are awaiting trial. So to put that number in perspective, there are more people in jail awaiting trial than are incarcerated due to a drug sentence. Pretrial detention has a number of known consequences or direct consequences. So incarceration imposes major disturbances for a defendant's life. Jail is crowded, unpleasant, unsafe. And while in jail, a defendant might lose their job, housing, or child custody. It's also expensive, obviously, for the taxpayer who must bear the bill. And of course, these costs must be balanced against potential benefits, such as reduced crime or ensuring that the defendant appears in court. So these are the factors that people normally take into account when considering whether or not to detain someone. But I want to introduce an additional set of concerns, which is that pretrial detention may have indirect or downstream consequences. So in particular, pretrial detention may affect the likelihood of pleading guilty, as well as the sentence received. If so, these downstream consequences should also be taken into account when designing pretrial policy. So it's long been postulated that pretrial detention puts a defendant at a significant disadvantage in their case. So if you're detained pretrial, for instance, and the prosecutor offers you a plea deal that allows you to go home right away, this could be very hard to turn down, even if you are factually innocent. And it obviously has consequences, probation and fines and fees, et cetera. In addition, it's harder to gather evidence if you're in jail, and harder, potentially to meet with your lawyer. Or harder even to pay for your lawyer, since you can't work while you're detained pretrial. However, it's arguably these concerns are overblown. To the extent that detainees have worse case outcomes, it could simply be because that they are, on average, facing more serious charges. They have lengthier criminal histories, stronger evidence against them, less money, by fact that they couldn't pay their bail. And by virtue of having less money, perhaps lower quality legal representation. So in other words, they are expected to have worse case outcomes regardless of detention status. As an empirical matter, it's difficult to provide really clear evidence that pretrial detention affects case outcomes. Since many of the differences between detainees and those who are released are invisible to the researcher, it's impossible to just control for them in a regression. Prior research on this topic has mostly consisted of correlational studies, or at least prior research up to a couple of years ago. Since then, there's been a handful of studies in addition to mine. And as such has been inconclusive as to the causal mechanisms. Isolating the impacts of pretrial detention requires an experimental research design. So what do I mean by that? Like, in an ideal world, from a research perspective, you would run something called a randomized control trial, where you randomly assign some people to pretrial detention and others to pretrial release. But of course, this is only ideal from a research perspective. There are a number of reasons why such an experiment would be unethical or even illegal. All right, so you can't do a randomized control trial to evaluate it the way you might a vaccine or something like that. An alternative method is to identify a natural experiment. In this context, a natural experiment would yield 2 or more groups of individuals who have different detention rates, but who are otherwise quite similar. So luckily, I was able to identify one such natural experiment in Philadelphia. So this natural experiment leverages the fact that defendants are randomly assigned to bail magistrates who vary in their propensity to set affordable bail. So let me explain the intuition behind this natural experiment. And we're going to start with just a kind of simple example here. So let's imagine that people that are arrested are randomly assigned to one of 2 magistrates. The first magistrate is a very strict magistrate. She sets very high bail that most people can't afford to pay. So as a result, people assigned to this magistrate have a high rate of detention. The second magistrate, meanwhile, has a low detention rate. She's relatively lenient. People assigned to this magistrate are less likely to be detained pretrial. Now, I've set up this whole thing saying that people are randomly assigned to the different magistrates. So on average, the group of people that see this strict magistrate should be close to identical to the group of people that see this lenient magistrate. They should be similar in terms of criminal record. They should be similar in terms of severity of the offense. They should be similar in terms of how strong and compelling the evidence is against them. So if at the end of the day, what we find is that the group of people assigned to this strict magistrate are more likely to be convicted than the group of people assigned to this lenient magistrate, we can infer that this is due to the fact that that people who are assigned to the strict magistrate were more likely to be detained. So this can provide evidence that pretrial detention causally affects case outcomes, because by virtue of analyzing 2 groups who are otherwise identical, except for their likelihood of being detained pretrial, we're effectively ruling out these alternative stories. So that's kind of the gist behind this research design. And it's basically what I do in Philadelphia. So it's slightly more complicated in Philadelphia. Philadelphia has 6 magistrates employed at a time. It's not literally a random assignment, but there's effectively random variation in which magistrate you receive because they work on this rotating schedule. And those assigned to the strict magistrate are more likely to receive bail and are more likely to be detained. All right, so I leverage this research design in a method called instrumental variables. We don't need to go into the technical details, but you understand the gist of it already. The gist of it is what I described in the previous slide. So using this method, what I find is that pretrial detention results in a 13% increase in the likelihood of being convicted, 18% increase in the likelihood of pleading guilty. It increases the amount of court fines and fees owed by 41%. And it increases the length of the sentence by 42%. So altogether, if you look across the 7-year period in my analysis sample, pretrial detention is responsible for 8,000 convictions and 16 million additional days in jail or prison. Note that these additional days in jail or prison, this is not from the fact of pretrial detention itself, but rather from the lengthier sentences received as a result of being detained pretrial. So the takeaway here is that pretrial detention is important. So it's important not just because of its direct costs, but also because of its indirect and downstream consequences. It puts defendants at a disadvantage in their case and likely increases wrongful convictions. So one of the implications here is that racial and socioeconomic disparities in pretrial detention will tend to reproduce and exacerbate racial and socioeconomic disparities in conviction and sentencing. Ameliorating disparities that arise from, say, using money bail to mediate pretrial detention will therefore help ameliorate downstream disparities as well. More generally, my research simply underlines the importance of the pretrial detention decision. Given its downstream consequences, this is a decision that should simply be made with care. So currently, bail hearings are often made in a rapid slapdash assembly line style fashion, slowing down, taking more time to weigh the evidence, allowing the defendant opportunity to rebut the claims are all likely to improve decisions made at this important juncture. In other words, the current system should take the legal standards seriously, detention prior to trial should be a carefully limited exception. Now, of course, some of these things require a change in law or policy or buy-in from the judiciary. This is a speech to prosecutors. So I want to discuss some of the things that prosecutors in particular can do on their own. So prosecutors can, for instance, reduce or eliminate their requests for money bail, given that money bail can create these disparities across wealth and across race and who gets detained. Prosecutors can assign more experienced attorneys to evaluate cases and determine if pretrial detention is really necessary. They can, among those that wind up getting detained, they can conduct an early screening to release people when they decide not to pursue charges. And finally, they can just in a general matter use their position of respect and influence within the system to advocate for a more comprehensive type of bail reform. So that's all I got prepared for you. I'm so happy to get to share these thoughts and look forward to questions if you have any.
Great, thank you, Megan. Alex Albright is up next.
All right. Hi, everyone. I'm Alex Albright. Thank you so much for coming, and thank you for inviting me to speak today. So I'm a research economist at the Federal Reserve Bank of Minneapolis, and I'm going to be talking today about a paper that used to be called If You Give a Judge a Risk Score. It's now being called The Hidden Effects of Algorithmic Recommendations. We're going to cover a lot of the same ideas, though. So there are lots of different algorithms currently used in the criminal justice system. We can think of examples when it comes to predictive policing, when it comes to pretrial risk assessments, sentencing, prison management, parole. And even if we just focus on pretrial risk assessment, so algorithms in the pretrial space, there are a lot of different ones used all across the country, and they're quite standard nationally. Despite the variation in what's used where, the goal is pretty consistent. The goal is to try to provide a data-driven way to advance pretrial release. Really what that means is trying to avoid detention for people who are unlikely to commit pretrial misconduct. And so how is it that algorithms are involved here? Well, there are algorithms that try to predict misconduct based on observable data, and then those algorithms are given to decision makers. However, a lot of the focus in the research space and policy space is on the algorithms in isolation. So how are they generated? What are the characteristics that are used? Can better ones be built? So can one be built where we keep jailing rates consistent but reduce crime rates, or vice versa? And what's really important to note here, though, is that algorithms are given to decision makers. So it's very rare that we see in the wild algorithms just making decisions without any discretion. And this is something that Megan talked about in a previous week as well. And not only are algorithms given to decision makers, but something that I think we often underappreciate is that they're given to decision makers with recommendations, with recommended actions. And this is important because let's think about how judges and decision makers might use algorithms. Well, it's been documented qualitatively that judges might think, okay, I'm not quite sure how to integrate just the algorithm output into my decision. So what I mean by that is if an algorithm determines that someone or some case is of moderate risk for misconduct, then the judge is told risk is moderate. How does a judge then update their decision-making based on that? It could go a few different ways. However, if they're also given a recommendation, which states, for this case, set lenient bail, it's a lot clearer to the decision maker how they're supposed to be updating their decision. They're given some sort of translation from the algorithm to action space. And that in and of itself is distinct from the algorithm, but potentially could be really important. So let me elaborate a little bit more on this theoretically. Let's talk about how an algorithm and a recommendation are distinct. So an algorithm, again, is predicting misconduct and then presenting some sort of relative information. So this is a prediction problem. Here I'm showing you a really simple example of how that could look. Let's say there's cases A, B, and C, and the algorithm basically tells us, okay, A is the highest risk and C is the lowest risk. What a recommendation then is coming in and doing is it's mapping from that output to action space. So the recommendation here is this green line, and the recommendation is saying, okay, give lenient bail to A and give harsh bail for B and C. And this is, again, distinct from the algorithm because an alternative recommendation, this one, where A and B are supposed to get lenient bail, is still consistent with the ranking of A, B, C, but the threshold is different. And so that threshold setting is just a totally different object than the algorithm itself. However, one challenge to interpreting and studying recommendations separate from algorithms is that they're often implemented at the same time. So if you look at policy changes that relate to algorithms over the last however many years, you'll often see that an algorithm is introduced alongside some sort of set of recommendations. So then when we're saying, oh, what was the effect of that policy, we're really sometimes muddling the effect of the algorithm with the effect of the recommendations that came into play as well. And so that's what I mean when I'm talking about the hidden effects of algorithm recommendations. What I'm saying is that recommendations are embedded in these systems, but we often do not study them independently. So what I'm doing in this paper is I want to try to isolate the effect of recommendations. So I'm leveraging a setting in which the algorithm that was available to judges was constant, but the recommendation was not constant. Recommendations were introduced at some period of time. So specifically, I'm going to be thinking about a context in Kentucky where the tool that was available is something called the Kentucky Pretrial Risk Assessment Tool. You shouldn't think of this as some complicated machine learning tool. This is really a checklist tool, or what's often called a rule-based formula, where you take a variety of risk components that I show here over on the right. They're all associated with points. You add up the points and you get a total score. This is a histogram that's just showing you how common each different risk score is in the population. These scores over here on the left are considered low risk, ones in the middle are moderate, and ones on the right are high. Now, what changed at some point in my study period is that we went from a system where there was no recommendation in place to at some point a new recommendation was introduced, and this recommendation was set lenient bail for low and moderate cases. So let's go back to this picture again. What the recommendation then is telling judges is it's recommended that you set lenient bail for all of these cases that are over here in the orange. And what's particularly notable to point out here is that this would mean lenient bail recommended for about 90% of cases. But before this, only about 32% of people are getting that lenient bail. So already you can see potentially how the recommendation would imply a big shift compositionally in decisions. So let's talk a little bit about predictions here. So what could be the impact of algorithmic recommendations? Let's go back to this really simple case where we're thinking about three different cases, A, B, and C. And let's say that when a judge has access to the algorithm risk score, they decide to give A lenient bail and they give B and C harsh bail. And I'm setting this up so that lenient bail is about close to 32%, which is what we saw in the pre-period. Now, again, what's introduced is give B lenient bail. That's the recommendation. Well, there's two main settings that I want to talk about here, two different sorts of outcomes. One is that the judge could say, okay, I'll give B lenient bail, but I'm also going to now shift A over to harsh bail. So I'm going to offset this recommendation. I'm going to keep things constant in the overall rates. So what's changing here is allocation is changing, but the overall composition of decisions has not. So 33% of cases are still getting lenient bail. In an alternative setting, what could happen is the judge keeps their decision-making consistent for A and C, but does shift B over from harsh to lenient. And so what's changing here is allocation, but also the composition. So you're moving from 33% to 67% lenient bail. But both of those different decisions are consistent with following the recommendation, but just in different ways. And so do we see evidence of one, where there's this offsetting effect and there's no compositional change, or two, where there's actually going to be a change in the overall composition of decisions? So let me just show you in picture form the answer to that question. What I'm going to show you here is this is really just a plot where I'm going to show you the percent of cases receiving lenient bail across the risk score distribution, which again is going from low on the left to high on the right. And I'm going to show you that both before and after this policy change. Everything over on the left is recommended lenient and things on the right have no recommendation. So what you see here is that the lenient decisions increase by about 50% for low and moderate cases, and you don't see offsetting effects over here on the right when it comes to high cases. And so this is then consistent with a story where algorithmic recommendations themselves, independent of algorithms, can impact judge preferences. One possible mechanism here could be lowering the cost of errors to judges. So this is something that would be consistent with court observation descriptions that talk a little bit about how judges and decision makers sometimes reference actually what it is that's forcing their hand or nudging them to make a certain decision. So in my remaining minute, I'll just talk a little bit about what the big policy takeaways are here. So algorithmic recommendations are very common in the criminal justice system, but we often understudy them relative to the algorithm in isolation. And the effects of these recommendations often are going to be hidden in our studies because they're bundled together with when algorithms are implemented. And so the big result that I have been highlighting for you is that recommendations themselves can shift more than the allocation of decisions. They can shift the overall composition. And so then how do we decide how to set these recommendations as a society? Well, this is no longer a prediction problem. This is now a normative decision that really is about the trade-offs between detention and misconduct. And so in this way, I just want to end on a note where I'm basically just saying that recommendations are actually something that are a bit of a political decision. They're a decision about how much we want to trade off between detention and misconduct. And there can be a lot of different recommendations, all of which are consistent with the same algorithm. So that's just a little bit of food for thought here. Thank you so much for having me, and I look forward to hearing the other talks.
Great, thank you, Alex. Next up is Amanda Agan.
Oh. All right. Well, thank you very much, Jen, for creating this panel and for inviting me to be on it. This is joint work with Jen and also Anna Harvey at New York University, which is all about misdemeanor prosecution. So, we got district attorneys across the country who are reducing prosecutions for nonviolent crimes. And these sorts of policies have made the news, with Chesa Boudin in San Francisco, George Gascon in Philadelphia, in Los Angeles, Larry Krasner in Philadelphia, Marilyn Mosby in Baltimore. We've had lots of these progressive prosecutors who are starting to implement policies of reducing prosecutions, particularly for nonviolent crimes, often for drug crimes and other sorts of nonviolent, mainly misdemeanor crimes. We've also seen a lot of backlash against these policies, and we've actually seen literal political backlash against some of these prosecutors who have now not been reelected, largely based on the sort of rhetoric around these sorts of deprosecution policies. And so the question that we asked in our research is, what is the impact of not prosecuting nonviolent misdemeanor offenses on subsequent criminal legal contact for the individual defendants who are beneficiaries of that leniency? So this paper is not asking the broader question of what is the impact of these sorts of non-prosecution policies on crime. Jen will talk a little bit more about some of our research on that next week, but we're talking for the defendants who actually receive this leniency. How is that impacting the probability that they end up with another arrest, with another charge? What is the probability that they end up committing further crimes in the future? Right? And there's reason to believe that if we were going to prosecute somebody, this could actually reduce their probability of recidivating in the future. They're experiencing the criminal legal system. They have some probability of being convicted and punished, or they might not want to go through that experience again. We hope in some sense that going through that has some deterrence effects and could actually reduce the probability that they end up recidivating, being arrested, and being charged at some point in the future. At the same time, charges themselves lead to marks on individuals' criminal records, and those marks can reduce the probability that these individuals have opportunities in the labor market or in the housing market, and could possibly increase the probability that they end up either committing future crime, being arrested, or being charged at some point in the future. So in order to study this question, we worked with the Suffolk County, Massachusetts DA's office, that's where Boston is located, and we collected data on nearly 68,000 nonviolent misdemeanor cases from that jurisdiction. These cases were charged or potentially charged sometime between 2000 and 2018. And importantly, our data includes information on the individual assistant district attorney who made the decision about whether to prosecute the case or not. So as the case came into the DA's office, there are different assistant district attorneys who might have made that very first decision. Are we moving forward with this case? Are we formally charging this case, or are we not? And that's going to be kind of the important decision that we are going to be focusing on in this research. Now, in Suffolk County, 21% of the nonviolent misdemeanor cases that we have are not prosecuted. So these individuals were arrested and booked by police, Police forwarded the charges to the prosecutor's office, and 21% of them, they immediately declined to even charge that case. And so again, it's going to be this decision that we're going to be focusing on, and how the decision to charge or not charge a defendant is going to be influencing the probability that they end up recidivating at some point in the future. So if we were just to compare the outcomes for misdemeanor defendants, nonviolent misdemeanor defendants, whose cases were not prosecuted or prosecuted, we see that individuals who were prosecuted are more likely to end up with another criminal complaint. Let's think of it as an arrest, another arrest within 2 years, another prosecution within 2 years, and kind of having a formal record of their subsequent prosecution within 2 years. And so, if we just compare these two groups, right, we do see that prosecution seems to increase recidivism, or non-prosecution on the flip side tends to decrease the probability that an individual ends up recidivating. However, cases that are not prosecuted are clearly different from cases that are prosecuted. Individuals who are prosecuted are more likely to have more counts associated with their case, to have a higher probability of having had misdemeanor or felony convictions within the past year, are less likely to be citizens, or there's a variety of characteristics that actually differ between prosecuted and non-prosecuted cases. And you can imagine the characteristics we can't measure may also be different between these two types of cases. And so we are going to leverage a design that is basically very similar, or basically the same as what Megan Stevenson was using in her bail paper. Of course, the kind of decision-making point is a different one, right? And so we're going to leverage the fact that cases are basically randomly assigned to assistant district attorneys who are making those initial decisions. And those assistant district attorneys vary in how lenient they are in that initial charging decision. So some of them might be not prosecuting something like 50% of the nonviolent misdemeanor cases that come in front of them, and some of them might be not prosecuting more like 5% of the nonviolent misdemeanor cases that come in front of them. So by chance, a defendant may get a lenient prosecutor and their case is more likely not to be charged, or by chance, a defendant may get a harsher prosecutor whose case is then more likely to be charged, right? And so luckily, we got a great explanation of this design from Megan before, and we can actually see that cases that are assigned to a lenient ADAs look the same as cases that are assigned to harsher ADAs, right? And so when we just looked at the case characteristics of those that were prosecuted and not prosecuted, we saw a lot of differences. But if we look at the case characteristics of those that happen to get a low leniency ADA, they actually look very similar to those that happen to get a high leniency ADA. And so this makes it so that if we can compare the outcomes of individuals with low, basically compare the outcomes of individuals with low and high leniency ADAs, right, we can start to understand the causal impact of non-prosecution on outcomes for these defendants. So what do we find? We find that not prosecuting a marginal nonviolent misdemeanor defendant reduces the probability of a new arrest for that defendant on average by 53% within 2 years, and reduces the number of new arrests for those defendants on average by 60% within 2 years. And those reductions are persistent. Even 6 years later, we're seeing large reductions in the probability that this individual defendant has ended up recidivating. Now, these results are particularly true for first-time defendants. Non-prosecution reduces the probability of a new arrest by around 70% for first-time defendants whose first charge is happening in Suffolk County. Now, again, I mentioned that next week, I believe, Jen will be talking about our broader research on non-prosecution and how that's impacting crime. The preview is that we have no evidence so far that this kind of non-prosecution policy is going to have broader sort of general equilibrium impacts on crime rates. So we're studying specifically in this paper the impact of non-prosecution on an individual defendant. We might be concerned that broader policies might be increasing crime overall, even if they're reducing recidivism for the individual defendants who receive that leniency. So far, we haven't had evidence of that, but you'll hear more details about that next week. So overall, we find that leniency, or we know that leniency in the non-prosecution of nonviolent misdemeanors is going to reduce the probability that an individual ends up with a mark on their record. It's going to reduce the time that an individual spends tied up in the criminal legal system, or they don't need to be coming back for various hearings, meetings with attorneys, things like that. And this person can now not be convicted. So these individuals are avoiding the potential record of a conviction and the punishment that might come along with that. And these forces do seem to be combining to reduce future recidivism, particularly for first-time defendants. And so it does imply that scaling back the prosecution of nonviolent misdemeanors could have large social benefits, although of course I hope there's a lot more research in this sphere in the future.
Thank you, Amanda. Joanna Lako is up next.
Great. All right. Thanks so much, Jen, for inviting me to present. I'm Joanna Lako. I'm the research director at the California Policy Lab at UC Berkeley. And this is joint work with several of my colleagues, including Alyssa Skog, who's on this call as well. Today, I'm going to talk about the impacts of felony diversion in San Francisco. And this is work that we've done with our longtime research partners, the San Francisco District Attorney's Office. And I think it will flow very nicely from all of the work that's been presented so far. All right, so the goal of this work is to estimate the impact of pretrial diversion programs that seek to address the underlying needs and challenges of individuals who are involved in the criminal justice system in San Francisco. And I think it's unique. San Francisco has a long history of diverting cases from the criminal justice system. And, you know, it's a progressive place, kind of pushing the needle on a lot of criminal justice reforms. And in particular, this program is interesting because it's focused on felony diversions. So these are not the easiest cases to divert. They're not the first time folks coming in. They're people that have significant criminal histories and who are dealing with a lot of issues. And the goal of the program is to say, okay, let's really think about the reasons that are underneath this criminal justice contact and see if we can address those reasons in order to prevent further system contact. So we're asking, what is the impact of referral to a felony diversion program on case outcomes and subsequent contact with the criminal justice system, focused on the collaborative court system, which is administered by the Superior Court of San Francisco, and they have specific court dockets that target very specific populations with services that they think are appropriate for those populations. So that's the drug court, behavioral health court, the young adult court, and the veterans court. And these are intensive programs that often take over a year for individuals to complete. So we're going to look at the impact of a referral to felony diversion programs, both on case outcomes and subsequent contact. And then we're going to look for differential impacts by demographic subgroups and the index arrest type. And the method we're going to use is going to sound very familiar to you now, because we're going to leverage the random assignment of felony cases in San Francisco to arraignment judges who are making that initial decision whether to divert someone or not, as an instrument for the diversion referral. So these arraignment judges vary in their likelihood of diverting individuals into the collaborative courts, and we're going to leverage that variation to estimate the effects on outcomes. Okay, so we're focusing on individuals with their first observed arrest that results in felony charges filed by the San Francisco District Attorney between 2009 and 2017. There have been a lot of things going on in San Francisco, so it's important to kind of point out the time period of when this is all happening. The case outcomes that we're focusing on are conviction in the central case, whether the case is dismissed, the time to disposition, and then a summary measure from the defendant's point of view that just captures whether the case had a positive outcome. And then we'll also look at subsequent criminal justice contact, including new arrests following arraignment, a new arrest for a felony offense following arraignment, and new convictions following arraignment. So the central issue that others have pointed out are that people referred to diversion are different than people who are not referred. And specifically in our case in San Francisco, individuals who are referred to diversion have more arrests on average and a higher likelihood of an arrest for a drug offense than those who aren't referred to diversion. So one might expect that these differences in kind of the baseline characteristics of individuals who are diverted and not would lead to differences in their case outcomes and their subsequent contact, the key outcomes that we're looking at. And this makes it really difficult to isolate the effect of the program from just the baseline differences. So the method we use, this random assignment to judges, using that as the instrumental variable for assignment to diversion, aims to address that selection process. Okay, so what do we find? there's a lot going on here, and I wanted to show the whole thing, even though there are a lot of numbers, because the two center columns are showing results if we don't use that instrumental variable and use the assignment to judges. And if we didn't use that approach, we would come to a very different conclusion about the effectiveness of the program than if we do use the more rigorous method. So if we don't use the approach, we would conclude that people who are diverted are substantially less likely to be convicted by a pretty big margin. We'd conclude that the time to disposition is much longer. And we'd conclude that people who are diverted are more likely to experience a positive outcome for their case. But when we try to address the selection into the diversion referral, we find a very different story. We don't find any effect on conviction. We don't find any effect on whether the case is dismissed, and we don't find any effect on the positive outcome. We do still find a persistent effect on the time to disposition, which makes sense because these programs take a long time to complete. And then we look at subsequent contact with the criminal justice system. And this is showing results both for rearrest and reconviction. And what we find is a significant decrease in the likelihood of a new conviction. And this is showing 2 years after arraignment, but this is robust up to 5 years after arraignment. We don't see any effect on rearrest. People are still getting arrested at similar rates, but those arrests are less likely to result in new convictions. We take a look at a bunch of different subgroups to try to understand, who's being affected by this program. There are 4 different collaborative courts kind of in our pool. We can't estimate effects separately for each of them because that would undermine our whole strategy. So we try to look at subgroups who we think may be more likely to take up some of these different programs. What we find are that females who are diverted are less likely to have a negative case outcome, and they're less likely to have subsequent contact up to 5 years post-arraignment on all the measures of subsequent contact that we measure. For transitional age youth, those under the age of 26, they're also significantly less likely to have a new felony arrest in the 2 years following diversion. And then people diverted on a felony drug arrest initially are more likely to have their case dismissed, and they're less likely to have a new conviction in the 5 years post-arraignment. And we can't say that all those people are going to drug court, but a lot of them are probably going to drug court. So what does this tell us? Diversion referrals appear to help people avoid future conviction, which is important. It's something that doesn't stick on your record later on. Felony diversion reduces the likelihood of a new conviction up to 5 years post-arraignment. We see no effect on arrest, even though these are people who have long criminal histories and have previously had a lot of contact with the criminal justice system. Diversion also seems to work particularly well for specific groups, including youth between the ages of 18 and 25, women, and people charged with felony drug crimes. And while we do see a longer time to disposition for individuals who are referred to diversion, we don't see any other effect on case outcomes overall. There's some subgroup effects. And I want to flag that this is just the first step in our research on this topic. I think there's a lot missing here. We went in trying to understand the effect of these programs, but we're not able to say anything in this study about whether people are actually getting the services they need to address their underlying problems. We have a sense of what they are. We see what diversion program they go to. Say they go to behavioral health court. We assume they have a serious behavioral health problem, substance use problem. But our next stage of this work is really going to focus on the impact of diversion on those specific outcomes. Do we see changes in people's health, physical health, their behavioral health, their housing outcomes, their mortality? And this is due to kind of a linked data set that we've put together in San Francisco. So I think it's really going to start filling in some of the gaps that were raised in this study. Thank you.
Awesome. Thank you, Joanna. And our last presentation is coming from Alyssa Skog. Oh, and you are muted if you're talking, Alyssa. Sorry, you were off my camera.
Shows us that we can still have these mistakes. All right, I'll start that again. My name is Alyssa Skog, and I'm a researcher at the California Policy Lab. I work with Joanna Lako, and I'm going to be talking to you all today about joint research with Yotam Shemtov and Steve Raphael that's looking at the impact of restorative justice. So first, to ground us, what is restorative justice conferencing? So in the United States, restorative justice conferencing has emerged as an alternative to the traditional criminal justice system. And the traditional criminal justice system focuses on sanctions and really isn't designed to understand the needs of either the victims or the individuals responsible for the crimes. So restorative justice as an alternative is really about holding people accountable through repairing the harm rather than imposing sanctions. So generally speaking, these conferences are typically a structured conversation where the person who's responsible for the crime, which is usually referred to as the responsible party, and the victim, which we call the harmed party, come together with their supporters. There's typically an external person who comes to prepare people to participate and then facilitate the discussion. And during the discussion, we hear from the harmed party. What was the impact of this crime on your life? And also hear from the responsible party, hearing what perhaps caused them to commit this crime. What do they need to do to prevent this from happening again? But the key here is really that the responsible party takes accountability and responsibility for the harm that was done. And then everyone works collectively to develop an action plan for the responsible party to repair this harm. The study, so again, our research question is looking at, can restorative justice interventions reduce recidivism? And then different from all my other panelists today, we have a very different research design. So in San Francisco, where this project took place, the DA's office piloted this program between 2013 and 2019, targeting youths 13 to 17 that are charged with a specific felony offense. So the program only had a certain number of seats, and they expected many more youth than the program could help to be eligible. So rather than having the prosecutor decide who gets to go to the program and who does not, they implemented a randomized control trial. So after the prosecutor reviews the case and determines if it's chargeable, they then either randomly assign the youth to treatment. So that means they're referred to the Make It Right program, or they randomly assign them to control. So that in the control regime here, they face traditional prosecution. A little bit more about the Make It Right program at a very high level, and this is going to be assuming someone is randomized into the program. So what does it look like? So it's a pre-charging diversion program, which I think is really important here. So youth who complete the program successfully are not charged on the case. And as I said before, the prosecutor assesses eligibility first and decides if the charge is going to be filed. There's some important eligibility criteria to flag here. So the crime must include a victim. Since it's a restorative justice and conversation, you need someone to be there to have the conversation. The prosecutor then contacts the victim to make sure that they're okay with the case going forward through the restorative justice program. And in San Francisco, none of the victims declined to have the case go forward through the restorative justice, or they were all kind of on board with this alternative approach. The case must meet additional eligibility criteria. So if there was an injury to the victim or a weapon was used, that's not going to be eligible. If the youth were gang affiliated, that will not be eligible as well. And then there's residency requirements as well. The juvenile must be a resident of San Francisco or Alameda County, which is across the bay where Oakland is. And so for context, the most common cases that are referred to Make It Right in San Francisco were felony theft, burglary, and assault. So these are, more serious offenses. And so let's say they meet that criteria, the case is then randomized to Make It Right. There's a second eligibility assessment that's done by Community Works, which is one of the nonprofit partners on the program. And what they're trying to do is really assess if the youth can participate fully in the restorative conference. So can they actually take responsibility for the crime? And do they have a support network that can participate in the conference with them and then help them implement the agreement? Then the restorative community conference occurs, and the responsible party and the harmed party and their supporters develop agreement for how the youth is going to repair the crime. And this can look like a lot of different ways. So there can be things that if there was a computer that was stolen, perhaps the juvenile is not able to pay for the whole cost of the computer, but instead they're going to offer to pay $50. So there's partial repair of that, repayment of the cost of that. And then there's going to be interventions to make sure that the juvenile is not in a position to commit this crime again. So then once the agreement is developed, the juveniles have about 6 months to implement, and there's intensive monitoring and support from additional nonprofit Huckleberry Youth, which I think is really important to flag in this program, where they're meeting in with them on a regular basis, but really coming at this through a supportive lens. It's very different than the stick of probation, but really focused on, okay, how do we get you across the finish line and how do we get you to complete this agreement? And then after successful completion, charges are not filed. So there's not that mark of a criminal conviction if a juvenile completes this program. And just to be clear, if at any stage in this process, the youth drops out, so if community works does the additional assessment and says they're not eligible, then they're going to be referred back to traditional prosecution. Similarly, if they start the agreement but can't complete, then they're going to be referred back to traditional prosecution, and the DA will automatically file charges in those cases. So what are our outcomes? So first, enrollment in Make It Right was incredibly high. So 4 out of 5 of those youth that were randomly assigned to Make It Right ended up enrolling in the program. And just to put that in context, in other similar studies of juvenile restorative justice programs in the United States, we find enrollment rates were below 50%. And why is this? What is a potential mechanism for this, and why is this important? We don't quite know. We can't say that causally through the paper, through our analysis rather, but some of the things some of the potential mechanisms could be that these are serious offenses. So these are folks that are facing a felony conviction, and that the alternative for this group is not a different diversion program, but the alternative is prosecution. So there is a true kind of stick to encourage them to participate. Second, our biggest kind of takeaway is that Make It Right leads to substantial declines in new arrest. So after 6 months, the youth that are assigned to Make It Right, there's a 44% lower arrest rate for those youth compared to those that are in the control group. And these persist after 1 and 4 years. So at 4 years, there's a 32% difference. And I think this is really important because, as we saw from the previous slide, with 80% enrolling, and we know that the program lasts approximately 6 months, you could think that there's a program effect at that 6-month mark. So those are youth that are still active in the program, but to see that this is substantial and persists up to 4 years. And we can look just kind of on the left-hand side briefly is this visually. So the black line is the probability of rearrest at different months for the control group, and then blue is those assigned to Make It Right, so our treatment group. And lastly, completion of the Make It Right program likely drives the declines in arrest. Now, we can't say this causally because there are likely important differences for why youth sticks with a program. They're correlated with their ability to remain arrest-free. But if we look at just the descriptive statistics here, these are fairly powerful. So 60% of those who complete Make It Right, 20% of those who complete Make It Right remain rearrest free or are rearrested at 12 months compared to 57% of those that do not complete Make It Right. So substantial differences between those that complete the program and those that do not. What are the policy implications of this? So for criminal justice practitioners and policymakers who are really interested in thinking about ways to reform the system, these are the kinds of programs that we think people should be looking at. We see that they are true alternatives and they generate substantial and long-lasting reductions in arrests, not just among youth charged with low-level offenses, but these are youth charged with fairly serious offenses. And we see that assignment, again, leads to substantial declines in rearrest, and that the effects are largest among those who complete the Make It Right program. there's a lot of questions that we have for additional research. And I think, one is to validate the scalability of Make It Right if it's adopted widely. This was a small pilot in a single county. So understanding how this is, how the effect when it's used in other jurisdictions. And then lastly, we talked a little bit about suggestive mechanisms through which some of these effects could be, whether it is the completion of the program, et cetera. We're really being able to study that with a larger sample in other jurisdictions to understand what the mechanisms are to these large effects we see. So thank you so much. I appreciate being part of this panel, and I will hand it back to you, Jen.
Wonderful. Thank you, Alyssa. And thanks to everyone for staying on time. So we will wrap up early. For those that are interested in seeing another round of research, our last session in this webinar series will be same time next week. You can register wherever you registered for this panel. And we'll have another set of 5 speakers, again, same format. So hopefully I will see most of you there. Thanks, everybody.